agents, open this door immediately!
Do you have a warrant? You can't just demand entry into my home.
We don't need a warrant. We have authority under immigration enforcement. Open up or we're coming in.
The door exploded inward. That Ring doorbell camera recorded every second. The body cams recorded every second. And 6 attorneys on an open Zoom call heard every word in real time. That footage would reach every law school in America, and it would cost him everything. Before we go further, where are you watching from? If stories like this matter to you, hit subscribe. The Constitution only works when someone holds a line. Denise Hargrove had spent 9 years on the federal bench. 43 years old, appointed to the United States District Court for the 11th Circuit at 34, one of the youngest appointments in the district's history. In 9 years, she had presided over more than 40 cases involving Fourth Amendment violations, illegal searches, warrantless entries, government overreach dressed up as authority. She didn't just know the law, she wrote it. In 2022, her landmark ruling placed strict limits on warrantless residential entry by federal agents, a decision that was appealed twice and upheld both times. Legal scholars cited it. Law professors taught it. Federal agencies were briefed on it. That Tuesday morning in May, Denise was working from home. Her laptop was open. A Zoom call with 6 attorneys was live, a routine case consultation that had started at 10. Coffee was still warm. Case files spread across the dining table, each one stamped with the seal of the United States District Court. It was an ordinary morning. In a different office, Agent Derek Paulson was having a different kind of morning. At 9:47, an anonymous tip came in. No name, no specific address confirmed, no documentation. The caller described in the report's own words, quote, suspicious, foreign-looking people at a residential address in the Brookhaven neighborhood. Paulson did not run a database check. He did not request surveillance. He did not verify citizenship status. He did not consult a supervisor. He called his team. They geared up, they drove, 11 years on the job, 3 prior internal complaints all unresolved, and a belief documented in his own field notes that immigration enforcement authorities superseded standard warrant requirements for residential entry. He had done this before. The difference this time was the Zoom call. Still open, still live. 6 attorneys listening to everything that was about to happen next. The Ring doorbell camera detected motion at 10:51. 4 figures in tactical vests marked ICE moved up the front walkway with the purposeful stride of people who had already decided how this would end. Paulson led. His hand was up before he reached the door. 3 hard knocks, not a request, a command. Denise heard it from the dining room. She glanced at her laptop screen. 6 faces on the Zoom call looked back at her mid-sentence. She held up one finger. Excuse me one moment. She didn't close the laptop. She didn't mute the call. She carried it to the kitchen counter screen still open and walked to the front door. She looked through the peephole. ICE vests, 4 agents, 1 battering ram resting against the porch railing. Her stomach tightened. Her face didn't show it. She had seen this before, from the other side of a courtroom. This is my home, she thought, and I know exactly what the law says. She spoke through the closed door, her voice steady. This is Denise Hargrove. I am the homeowner. Who are you and what is the purpose of this visit? Paulson's response came back hard and fast. Federal agents. We have information that undocumented individuals are residing at this address. Open the door. Denise didn't open it. My name is Denise Hargrove. I am a United States District Court judge for the 11th Circuit. I am a United States citizen born and raised in Atlanta, Georgia. Before this door opens, I require you to present a valid judicial warrant authorizing entry into this residence. A pause. Brief. Ma'am, we have authority under immigration enforcement statutes. We don't need a warrant. Denise's voice didn't waver. That is incorrect. The Fourth Amendment to the United States Constitution prohibits unreasonable searches and seizures. A private residence requires either a judicial warrant or voluntary consent before federal agents may enter. Immigration Enforcement Authority does not override constitutional protections. That has been the established law of this circuit since at minimum 2022. She didn't add since my ruling. She didn't need to. On the kitchen counter, 6 attorneys on an open Zoom call had gone completely silent. One of them had already opened a notepad. Another had already picked up his phone. Paulson's voice came back tighter now. Ma'am, you have 10 seconds to open this door or we are authorized to enter by force. Denise spoke one more time. clear, measured, recorded. I do not consent to entry. I am requesting your badge numbers and your supervising officer's name. You do not have a warrant. You do not have my consent. Any forced entry into this residence will be a violation of federal law. Paulson didn't ask for badge numbers. He nodded to the agent behind him. 3, 2. The battering ram connected with the doorframe and the sound was enormous. A crack of wood and metal that carried through the open Zoom call and made 3 attorneys physically flinch on camera. The door flew inward. Paulson and his team poured through. Denise stumbled back, one hand against the wall to keep her footing. Hands up. Don't move. Show us your hands. The voices overlapped into a wall of noise that filled the front hallway. She raised both hands. Her voice came out sharp and precise even now. I am not resisting. I am Denise Hargrove, United States District Court Judge. You have entered this residence without a warrant and without consent. Everything happening right now is being recorded. She was right. The Ring camera was recording from the broken doorway. Paulson's own body camera was recording from his chest. The neighbor across the street had stepped onto her porch when she heard the crash and had her phone up. And on the kitchen counter, 6 attorneys were still on the Zoom call. Live. Every second of it. Paulson didn't know about the Zoom call. They moved through the house like they were clearing a crime scene. 2 agents swept the back rooms. 1 took the hallway. Paulson stood in the center of the living rooms, his body camera running, his eyes moving across the space the way agents are trained to assess threats first, everything else second. What he saw was a dining table covered in federal case files, a laptop on the kitchen counter screen open, bookshelves lined with legal volumes, federal rules of evidence, constitutional law United States Code annotated editions with post-it tabs marking specific sections, framed certificates on the wall, a graduation photo, a swearing-in photo, black robes, hand raised, standing in front of a federal seal. He didn't stop. Get her security, he said to the agent behind him. Denise was guided to the dining room chair, her hands pulled behind her back. The handcuffs clicked into place in her own dining room, surrounded by her own case files directly in front of her open laptop. She looked straight ahead. She did not cry. She did not beg. On the Zoom screen, no one spoke. They were watching. All 6 of them. The agent searching the back hallway came to the study doorway and stopped. He stood there for a moment, then called out to Paulson. Hey, you need to come look at this. Paulson walked over. On the desk, a nameplate. The Honorable Denise Hargrove, United States District Court, Northern District of Georgia. Beside it, a court seal. A stack of signed orders. A Federal Judicial Commission, the official document signed by the President of the United States, appointing Denise Hargrove to the federal bench. The agent looked at Paulson, said nothing. Paulson looked at the desk, said nothing. Then get her ID, verify. That single word verify would be quoted in the lawsuit 15 times. He had not verified before driving to this address. He had not verified before picking up the battering ram. He had not verified before counting to 3. But now, standing in front of a Federal Judicial Commission with his own body camera running, with an attorney handcuffed in a chair 20 feet away now, he wanted to verify. The agent brought Paulson her credentials, her judicial ID, her bar card, her passport. Paulson looked at them. His jaw tightened. In the kitchen, the Zoom call was still live. Attorney Michael Reeves, 30 years in federal civil rights litigation, 2 Supreme Court appearances, had already dialed a second phone. He reached the Chief Judge of the 11th Circuit at 10:59. He described what he had witnessed in 60 seconds flat. Attorney Sandra Park had already called the FBI field office in Atlanta. The other 4 attorneys were calling each other, comparing notes, confirming what they had heard, establishing a chain of witness testimony that was, in effect, building itself in real time. 8 minutes after the door came down, 3 institutions knew what Derek Paulson had done. Back in the dining room, Denise spoke. Her voice was quiet, controlled. The tone of someone who has presided over a courtroom for 9 years and understands exactly what words mean and when to use them. Agent Paulson, I want you to listen carefully. In the case of United States versus Alvarez, decided by this circuit in 2022, the court held, and I authored this opinion, that no immigration enforcement authority, statutory or regulatory, supersedes the 4th Amendment's warrant requirement for entry into a private dwelling. Anonymous tips absent independent corroboration do not constitute probable cause sufficient to justify warrantless residential entry. Any evidence obtained through such entry is inadmissible. Any agent conducting such entry may be held personally liable. She paused. That ruling is binding in this circuit. You are standing in this circuit. You are in violation of that ruling right now. Paulson said nothing. The body camera on his chest recorded 12 seconds of silence. Then his radio crackled. His supervisor's voice came through. Paulson, stand down. Do not take any further action. We have a situation. He didn't respond immediately. The handcuffs stayed on Denise Hargrove for 4 more minutes after that call. Those 4 minutes, documented by body camera timestamp, by ring footage, by Zoom recording, would later become the basis for the punitive damages argument. Not the entry itself. Not the battering ram. The 4 minutes after his supervisor told him to stand down, and he did nothing. The lead attorney on the civil rights case would call it the most expensive 4 minutes in ICE enforcement history. A federal judge, handcuffed in her own dining room, surrounded by her own case files, citing her own ruling to the man who broke down her door. What would you have done? The FBI arrived at 11:13, 22 minutes after the door came down. 2 agents in plainclothes badges, visible moving up the front walkway with a different kind of purposefulness than Paulson's team had shown. Not a raid, a reckoning. The senior agent, a woman named Supervisory Agent Carol Whitfield, walked straight past Paulson without speaking to him. She went directly to the dining room where Denise Hargrove was still seated, hands still cuffed behind her back. Whitfield looked at the handcuffs. She looked at the Federal Judicial Commission on the desk. She looked at the open Zoom call on the kitchen counter, where 5 attorneys were still on the line, and a 6th had stepped away to take a call with the chief judge. She turned to the agent standing nearest to Denise. Take those off, right now. The handcuffs came off at 11:15. Denise rubbed her wrists once quietly and said nothing. Whitfield then walked back to the front hallway where Paulson was standing. His body camera was still running. He had not turned it off. Either he hadn't thought to, or some part of him understood that turning it off now would only make everything worse. Agent Paulson, walk me through exactly what you had before you came here, he told her. Anonymous call, suspicious, foreign-looking individuals. Address in Brookhaven. Whitfield looked at him for a long moment. That's it. That's what he had. She asked the next question slowly, the way experienced investigators ask questions when they already know the answer. Did you run the address through the Federal Resident Database number? Did you request a surveillance window before approach? No. Did you attempt to identify the residents through any available records before initiating forced entry? No. Did you consult your supervisor before deploying the battering ram? No. Whitfield closed her notepad. 11 years on the job. And not one verification step. Not one. During discovery, the original tip was pulled from the ICE intake system. The full text of the anonymous call ran to 4 sentences. A neighbor reported in the call log's own words, suspicious, foreign-looking people coming and going from the residence at the listed address. No names. No physical descriptions beyond that phrase. No time frame. No corroborating detail of any kind. The call had been logged at 9:47 in the morning. Paulson had deployed his team at 10:31. 44 minutes, no verification, no database check, no attempt to identify who actually lived at that address. 4 agents, full tactical gear, and a battering ram mobilized on 4 sentences from an anonymous caller who couldn't be identified and was never located. The plaintiff's attorney called it during opening statements the single most reckless deployment of federal force she had seen in 23 years of civil rights litigation. The jury would agree, but the tip was only part of the story. Paulson's internal record came out during discovery. 3 prior complaints, filed by 3 separate individuals across 2 jurisdictions. All 3 alleged improper entry or excessive force during residential ICE operations. All 3 had been reviewed by his direct supervisor, Field Operations Director James Coulter. All 3 had been closed without disciplinary action. Coulter's notes on the first complaint agent acted within operational parameters. On the second, insufficient evidence to support finding of misconduct. On the third, filed just 9 months before the Hargrove incident, behavior consistent with field conditions at time of entry. Coulter knew. He reviewed the files personally. He signed off on every closure. When the plaintiff's attorneys deposed Coulter, they asked him one question and let the silence do the work. After 3 complaints alleging improper residential entry, What additional training or supervision did you provide? Agent Paulson Coulter's answer was 4 words. We monitored the situation. Those 4 words would later form the backbone of a $14 million punitive damage award against the agency, underscore, 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 underscore. The evidence that reached the jury was unlike anything that courtroom had processed before. The Ring doorbell footage ran 4 minutes and 17 seconds. It showed the approach to the demands, the countdown, the entry. It showed Denise Hargrove standing at her own door, asserting her constitutional rights with the precision of someone who had spent 9 years enforcing them. It showed the moment the door came down. Paulson's own body camera ran continuously for 31 minutes. It showed every room he entered. It showed the Judicial Commission on the desk. It showed the handcuffs going on. It showed the 12 seconds of silence after Denise cited her own ruling directly to his face. It showed Whitfield's arrival. It showed the handcuffs coming off. The neighbor's cell phone footage captured the exterior 4 agents, 1 battering ram, a broken door, a quiet Brookhaven street that would never feel the same to the people who lived on it. And then there was the Zoom recording. 41 minutes of uninterrupted audio and video. 6 attorneys as direct witnesses. The full escalation from first knock to FBI arrival, captured in real time by accident, because Denise Hargrove had stepped away from a meeting and hadn't thought to close her laptop. Paulson had broken down the door of a federal judge in front of 6 attorneys who were already on a recording platform. He had done it believing no one powerful was watching. He had never been more wrong. Paulson lost his badge on the same day the criminal referral was filed. All 4 agents were terminated within 30 days of the incident. The termination letters cited conduct unbecoming violation of agency protocol and failure to adhere to constitutionally mandated procedures for residential entry. Paulson's pension, 11 years of it, was frozen pending the outcome of criminal proceedings. Paulson lost his badge, his pension was frozen, and he now faces a barrage of federal criminal charges. He orchestrated the violent breach of a federal judge's home based on nothing more than an unverified, anonymous, and racially motivated tip. Does this punishment fit the gravity of his actions? Let me know your thoughts in the comments. The trial lasted 11 days. The federal courthouse in Atlanta was packed every morning. Retired attorneys, law students with notebooks, neighbors from Brookhaven, people who had seen the Ring footage when it went viral and had driven to the courthouse to watch what happened next. Denise testified on day 3. She sat in the witness chair of a federal courtroom, a room nearly identical to the one she had presided over for 9 years. And she described that Tuesday morning in a steady voice that didn't break once. She described waking up, making coffee, opening her laptop, taking the Zoom call, hearing the pounding at her door. She described looking through the peephole and recognizing immediately what she was seeing and recognizing just as immediately that it was wrong. She described citing her own ruling through a closed door to an agent who didn't know whose door he was breaking down. And she described the handcuffs, the 4 minutes after Whitfield called for them to be removed when they stayed on anyway. The sound of her own dining room, her own case files around her, the seal of the United States District Court on the desk 3 feet away. I have spent 9 years in federal courtrooms, she told the jury. I have enforced the law. I have protected the rights this country is built on. And on a Tuesday morning in May, those rights meant nothing to the men who broke down my door. The jury deliberated for 9 hours. They came back unanimous on every count, $20 million. $6 million in compensatory damages for the violation of constitutional rights, the physical and psychological harm, the destruction of property, and the lasting impact on Denise Hargrove's sense of safety inside the home she had built her life around. $14 million in punitive damages calculated specifically, the jury foreperson stated in post-verdict remarks, to send a message that could not be ignored, reinterpreted, or quietly closed like a complaint filed in triplicate and shelved. During closing arguments, Denise's lead attorney had read directly from the 2022 ruling, the one Denise authored, the one that had been briefed to federal agencies, the one that said in clear and binding language that no immigration enforcement authority overrides the Fourth Amendment's warrant requirement for residential entry. She read it slowly. She let it sit. Then she looked at the jury and said the agent who broke down this door was required by law to know this ruling. He didn't know it, or he knew it and didn't care. Either answer should concern every person in this room. The jury was concerned. All 4 agents were terminated. ICE announced a mandatory policy change: supervisory approval required for all residential entries. Anonymous tips must be independently corroborated before deployment authorization, and all field agents must complete quarterly constitutional law training with documented sign-off. Coulter retired before he could be formally disciplined. His retirement did not stop the civil liability findings against the agency he had run. Paulson's criminal case moved forward under 18 U.S.C. Section 242, deprivation of rights under color of law. A federal charge, the kind that carries prison time. Denise Hargrove returned to the bench 6 weeks after the incident. She walked into courtroom 1850 of the Richard B. Russell Federal Building on a Monday morning, took her seat, and called the first case. The attorneys in the room stood when she entered, as they always do for a federal judge. She nodded. She opened the file. She was back. The $20 million verdict was written into the case law of the 11th Circuit as a binding precedent on punitive damages for warrantless residential entry. Harvard Law added it to the curriculum. The Brookhaven ring footage became required viewing in federal law enforcement training programs across 6 agencies. And the original door frame splintered lock, destroyed, wood cracked from the first hit of the battering ram, was preserved as evidence and later transferred to the Georgia Civil Liberties Union, where it stands in their lobby today. Not as a symbol of defeat, as a reminder. Derek Paulson was not an anomaly. He was the product of a system that had reviewed his record 3 times, seen what he was capable of, and done nothing. A system that told him through inaction and signed approvals that his instincts mattered more than the law, that his badge was bigger than the Constitution, that no one important enough would ever be standing on the other side of the door. He was wrong about one thing that morning. He walked up to that door believing he had all the power. He walked away from it having handed every bit of that power to the woman he had handcuffed in her own dining room. The camera was always on. It always is. Underscore, 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 underscore. If you believe no badge should override the Constitution, share this. These stories only matter if people hear them. Subscribe, because there are more cases like this one, and every one of them deserves to be told. And tell me in the comments, should Paulson face prison time? The jury gave $20 million. The DA has a decision to make. What do you think justice looks like here?